Hello, my name is Morgan Prost, and I will be presenting this case brief on Hosanna Tabor Church and School versus the Equal Employment Opportunity Commission. The parties involved in this case, as the plaintiffs, are the EEOC on behalf of Cheryl Parrish, who is the fired called teacher or commissioned minister in this case. And the defendant is Hosanna Tabor Evangelical Lutheran Church and School, the former employer of Cheryl Parrish. The key issue in this case was revolving around whether or not the ministerial exception rule under the First Amendment applied to Cheryl Parrish and her employment as a commissioned minister, even as she was serving as a called teacher. We will get more into the details of that shortly. Now that we have looked at the issue, let's take a step back and let's think about what we need to be looking at in this case. My first question was, what are our rights exactly under the First Amendment? And then second, what is the ministerial exception rule exactly? Let's take a look at the First Amendment and what it says specifically. It states, Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or the right of the people peacefully to assemble, and to petition the government for a redress of grievances. So, under that protection of our rights in the First Amendment, that part where it talks about Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. Under that, there is this ministerial exception. And did a little research, and the Equal Employment Opportunity Commission compliance manual specifically puts it as religious organizations and religious educational institutions, so Hosanna, Tabor Church and School, are exempt from certain religious discrimination provisions, and a ministerial exception bars Title VII claims by employees who serve in clergy roles. I'll get into what this signifies a little bit later in this presentation, but just to kind of give you the background so you can start thinking about it as we go into the facts and procedures of this case. So now take that background that I just kind of gave you and use that as your lens to look through the facts of this case. So starting off, Cheryl Parrish went through training to be a certified called teacher for the Missouri Evangelical Lutheran Synod. She was then called by Hosanna Tabor to be a commissioned minister, where she taught religion class, helped with devotions, led prayers, led chapel services several times yearly, and taught other secular classes. The church and school had teachers that are both called teachers, and that's what these commissioned ministers are, and they also have lay teachers. The lay teachers have the same duties that the called teachers have. However, they're not called by the congregation to serve as a commissioned minister. Two very separate and distinct things, and it's important that we keep those two separate. So in 2004 and 2005, Parrish began to develop narcolepsy and then went on disability. In January of 2005, she gave notice to the school and the school's principal that she'd be able to return to work beginning in February. The school's principal then responded to her stating they had already hired a teacher to serve in her stead, and that Parrish should really take some more time to recover before she returns. Furthermore, the school then actually offered to pay for part of her insurance premium to help cover the medical expenses if Parrish would agree to resign from her call. Parrish did not accept the offer and refused to resign. Last facts here for this case. When February did come around, Parrish, of course, showed up like she said she would, and she said that she wouldn't leave until she was presented with some documents stating that she had reported to work. Later, she was informed that likely she would be fired. There was an exchange then between Parrish and the school, and Parrish informed them that she intended to assert her legal rights, to which the chairman of the school board informed her that the congregation would be considering rescinding her call at their next meeting. The congregation then did go on to vote in favor of rescinding Parrish's call, and she was later sent a letter of termination. Now that we know the facts of the case, let's move on to the procedural side of it. First off, Parrish filed a complaint with the EEOC stating that she was discriminated against in violation of the Americans with Disabilities Act. She had intentions of suing them because they discriminated against her disability, which is a good case because of her situation with her narcolepsy. That would probably be a fair case in her favor. And the goal ultimately was to win her unemployment benefits. The EEOC then sued Hosanna Tabor, and Hosanna Tabor argued that the suit was barred by the First Amendment and the ministerial exception. The district court then agreed and granted summary judgment in Hosanna Tabor's favor. However, the Sixth Circuit vacated and remanded, and it concluded that Parrish did not qualify as a minister under the exception. The case then, of course, went on to the Supreme Court, where there was a unanimous decision to overturn the ruling of the Sixth Circuit. Direct comment here from the Supreme Court. The formal title given Parrish by the church, the substance reflected in that title, her own use of that title, and the important religious functions she performed for the church. They concluded that Parrish was a minister covered by the ministerial exception. The judgment of the Court of Appeals of the Sixth Circuit was then reversed. I had started off wanting to do a holding joke on this one. That was a lot of information, obviously. That's a lot to kind of grasp. But the holding, yes, ministerial exception applies to a commissioned minister that has been called by a congregation to serve in the capacity of a called teacher, such as Cheryl Parrish was. Having looked at the issue, the facts, the procedure, and the holding, we're now really able to look at the reasons and the reasoning that the ministerial exception does apply in this case. I had a lot of information here originally. I think I've condensed it down to things that I take the most weight in my understanding of why it applies in this situation. So, Hosanna Tabor appointed Parrish as a commissioned minister directly. She was called by the congregation to be the commissioned minister. Yes, she was a teacher, but that was really by vocation and not by title. And the Supreme Court really wanted them to focus on the title and not so much the duties involved with the title. And I'll get to that later. So, when she was called, she was issued a diploma of vocation and the title Minister of Religion commissioned. In becoming a commissioned minister, she also had to petition the synod district in her area, by submitting her transcripts from her education, a letter of recommendation from her congregation, and a personal written statement, along with a questionnaire that had several questions pertaining to the ministry. Another one is they voted on the matter and recognized it as God calling her to teach. Sounds ministerial to me, and that's with a limited knowledge of the background. On her taxes, she also further claimed special housing allowance, which is only allowed for employees of the church that are making a living in, quote, the exercise of ministry. That one really sealed it for me. And lastly, her job duties as a called teacher did revolve around the mission of the church. We looked at that in the facts of the case. I kept this case separate really for two separate rulings. You got the Sixth Circuit Court, and that's really the first part of what I focused on. But then I also really focused on the Supreme Court's ruling, which ultimately was the final ruling. And that's what this part focuses on. So the Supreme Court really commented on three errors that they felt the Sixth Circuit Court committed. First off, there was a failure to recognize Parrish as a commissioned minister. They felt as though that the Sixth Circuit Court was wrong in judging the title of the employee as being not important. They focused on the duties and they really didn't give a lot of weight to the title. And they felt as though that was a big oversight on their part. Second, they focused too much on the subject of how the lay teachers had the same job duties that the called teachers did, both religious and secular. I thought that was a fair point on the defense of the Sixth Circuit's court, but it still does not change the nature of the relationship between the church and the position of the commissioned minister, even as a called teacher. And thirdly, there was a lack of focus on the religious duties of Parrish and an overemphasis on her secular tasks. A large issue that the Equal Employment Opportunity Commission was holding onto the opinion that the ministerial exceptions should be limited to employees who perform exclusively religious functions. The Supreme Court did not accept that view, and their argument really was that religious leaders of the congregation have other tasks that are not secular as well as religious. You know, they're often jacks of all trades. They do a lot of different things that are not specific to religion. And I thought that was a pretty insightful decision on the part of the Supreme Court. So ultimately, the result here is the Sixth Circuit Court of Appeals ruling was overturned by the Supreme Court, and they ruled in Hosanna Tabor's favor. Well, what are the effects and the important takeaways from this case? First off, the ministerial exception under the First Amendment is going to continue to revolve around the title and religious functions of that position that's being questioned. And that is going to be a precedence that's going to continue to hold for future cases. The lower courts are probably going to look more attentively as to whether the defendant is a recognized member of the clergy. Although their tasks may not revolve directly around ministry, that does not mean that their title and the way they were brought into the employment of the church, such as being called by the congregation or voted in by the congregation, that's all still relevant. Lastly, schools that are privately run by churches are going to continue to have these same protections under the First Amendment and under that ministerial exceptions clause. Those are my calculated takeaways, but here are a little bit more of my personal takeaways. I see this as two things, really. I see it as a win for religious organizations, but I also see it as a loss for called teachers. And that's a little bit conflicting for me because I like law, but this one, I just don't know. My family is a lot of called workers, and they're not pastors. They're not preaching in the pulpit. They're not leaders of the church. But yeah, they all would still fall under this ministerial exception. They've been called by the synod, and they've been called by religious organizations. So I'm happy because this case really does protect religious organizations, and I see what is going on here, and I'm happy about that. But at the same time, I think that they probably could do a little better justice in protecting the rights of the teachers, not necessarily the pastors, regardless of whether they're called to be commissioned ministers or not, because they're serving in a capacity that's completely different from the commissioned minister. And in my opinion, this is just a loophole. Again, opinion. Facts are one thing, and I like the facts, and I think my first 3 points really stick to that. Opinion, that's more the opinion side of it. I hope you enjoyed this presentation. It was a very interesting case to study, and I felt as though I learned a lot of practical things that have been a part of my life that I may have not even known about growing up. So I'd just like to thank you for watching this presentation, and I hope you enjoyed it.